Well, I wasn't sure that we weren't going to be doing this program over the telephone. Colin Flannigan found himself in that huge traffic backlog coming in out of the west side and called the studio and said, Hey guys, just to let you know, I am in traffic and there is nowhere to go. Mr. Flannigan, good morning. Welcome. You made it through the gridlock, the bridge lock, and all the rest of the lock.
Good morning. It was a bit of a dicey moment or two as I was looking at the clock.
This is radio. We do things over the phone.
Absolutely.
Yeah, but it's nice to have you in the studio, and I appreciate you being here. I'm particularly intrigued by the subject matter of today's program conversation, and it's expressed in one line: estranged children and how they are treated in wills. A huge, complex case, really. Simple line, simple thought, complex legally.
Absolutely. And the way I look at it is what it stems from. It's from complex relationships. I mean, not every family is everyone gets along. I mean, we'd all like to think that. I know, as shocking as that might seem.
No kidding. Just the fact that we came from the same sperm, the same egg, and the same womb, and the same parents, the fact that we don't get along shouldn't surprise people.
It shouldn't. And I know a lot of people sometimes feel almost a little bit of shame in that when they start having these conversations, and you really shouldn't, because family dynamics are complex. You know what? Not every relationship is a good one. Sometimes there's things that occur throughout our lives that challenge that relationship and cause strain on it and can ultimately lead to estrangement. So,
and I think to a degree we sort of all think of it right now as mom, dad, and 3 kids. That's the family. But in these days, increasingly, it's mom, second wife, and 4 kids. And 2 of them are from her previous relationship, and 2 of them are from his previous relationship. And we're trying to do the what was the family show? The Brady Bunch. We're trying to do a Brady Bunch here. We're trying to blend everybody together. We're trying to make everybody get along. Because mom and dad truly do. The mom and dad number 2, or dad number 1 and mom number 2, we really do care about each other. And it's a challenge when the kids find that they have absolutely nothing in common with these new siblings that have been introduced into their lives.
And you raise a very good point. There seems to be that change from the old, quote, nuclear family to more towards this blended family. And what happens to those family dynamics? And it's unfortunately a common situation where you have the relationship between the children from the first marriage, even the relationship with their parent, starts to fall away.
Yeah.
And as the parent becomes more involved with their spouse and their spouse's children, what happens with that relationship? How does it actually go from there? Or even more interesting yet, sometimes you've got some children that maintain a relationship and others that don't.
Right. It falls off. Mm-hmm. I always knew that you were mom's favorite because she continued to talk to you, but she totally ignored me.
Well, I'm sure my brother and sister would disagree with you on that point.
The other side of it is that, okay, we have mom and dad and 2 kids. When the divorce happens, mom goes one way with 1 kid, dad stays with another kid, then brings his new girlfriend, becomes his new wife, and so on. At the same time, the mom who left the relationship with the other child in tow, that child remembers the family holdings, for lack of a better word. There was 3 cars. There was this big house. There was a swimming pool in the backyard. And as they get older, they suddenly realize value and valuation of property and resources. And by God, when it comes time to divvy that up, given that I spent 11 years there, and that was 11 years, that was my pool as a kid, I better get a share of the proceeds.
Well, even better yet, when you've got some kids that don't have assistance through their minority. For some reason, they have that estranged relationship. They're out on their own at 16 years old, and they put themselves through. There raises questions of should they be entitled to something then? And I'll get into a little bit about as far as how the courts are going to look at that.
Okay, so we've defined through about 5 different scenarios: complexity, variations on a theme, and the challenges of building this blended relationship. When push comes to shove, when it comes to hard dollars, what has to happen?
Well, I think this was a great intro into the topic because one of the points I wanted to stress is that it is a complicated situation with many different variables. So I'm going to talk about it in general terms, and each individual circumstance will need to be addressed slightly differently. But the whole idea I want to show is that there's many different situations that can arise.
Okay, then I want to put this forward right now to people who are listening. We're happy to take your calls at 250-862-2525. I'm at some point in time going to put my own scenario on this because when I saw Colin Flannigan's subject line, I was intrigued only because I'm living part of the scenario as he sets it out. But more to the point as well, should you choose not to involve yourself in a radio conversation feeling that it's too public or you might be identified, he can be found at FH&P Lawyers. Family law is one of the areas in the expertise that he can talk to. All you have to do is go to Google, type in FH&P, and when you get the drop-down file for the listing of the lawyers who are in the practice, who are in the business, Colin Flannigan is the guy that you want to talk to. Okay, so where's our starting point?
All right, just as a quick little point of clarification, wills and estates is my area.
Sorry.
That's okay. Family law, we do have some fantastic family law lawyers
Yes,
at our firm. So I'll gladly, if anyone does have any questions regarding family law, we do have some fantastic lawyers to look after you as well, too. I want to talk about it from a wills and estates perspective, though.
Okay.
So one of the first questions I get asked when someone comes in and doing an estate planning conversation, sometimes people have an idea already. They want to say, okay, I want this to go to this person, this to go to this. And sometimes people are wondering with, a question right off the bat where I can tell that there's something more beneath the surface. And it's, do I need to treat everyone the same?
Yeah.
And right there, you start to get an idea, okay, there's some complexity to relationships here. And we can look at this in two different ways. The short answer is yes and no. Do you have to treat everyone the same? Yes, there is prima facie expectations that children are going to be treated equally to discharge moral obligations, but that can be rebutted, and it can be addressed because of certain circumstances. There can be valid reasons why we don't want to treat everyone the same. It might be a situation of perhaps one of the kids has got a drug addiction.
Right.
And if we give them a gift outright, it's going to be harmful towards their health. So we need to address that. Maybe one of the beneficiaries is a person with disabilities and receiving assistance. That needs to be addressed and treated differently.
Do they need a bigger share?
Do they get a bigger share, and how do you treat that share as well, too, so it doesn't affect their entitlement?
Mm-hmm.
Other issues arise, whether it's just an estrangement from a child or maybe it's a situation of a blended family, what we started talking about, where, you've got a spouse, new spouse, you want to leave everything to the new spouse. What about the kids from the first one? You still have a decent relationship with one child, but what about the other one? So there's all these different factors that can weigh into the question. So we start saying, okay, well, what is wills variation? Because I think that's got to be a topic we need to address right off the top. And wills variation it's still known as wills variation or Wills Variation Act, even though that act has been subsumed into WESA, the Wills, Estates, and Succession Act. Mm-hmm. In short, what it is dependence relief legislation. It's the legislature saying that a will maker has got legal and moral obligations to certain classes of beneficiaries. That's spouses, that's children. Now, children also includes independent adult children. So it's not just dependents. So this comes to really the question of estranged children, where they really fall into that category. So as I said, the first question usually is, should we treat everyone equally? And that's the rule of thumb, is saying, well, by dependence relief legislation, we should on our moral obligations, but why aren't we? So we start looking into some of these types of factors and start saying, okay, well, how's the relationship with Bobby? You haven't seen Bobby in 20 years. And that's often how this conversation might go. It might be like, well, I don't want to leave anything to Bobby. Bobby's not part of my life anymore. Bobby's not even my son anymore.
Bobby doesn't even call, doesn't write, doesn't come by, doesn't check on my health, knows probably that I've been sick or hurt, but doesn't contact me.
Exactly. Now, that's not the end of this story. Most people think, well, okay, how can we address this in the will? Say, should I leave $1 to Bobby? Should I leave nothing and just say, I've considered these obligations, but since I don't have a good relationship, that's the end of the story. That's not really the end of the story, though, especially when we're talking about estranged children. It's a little more complex than that. Because what the courts are really going to look at, they're not going to look at not only, well, when dealing with children, they're going to say, okay, what's the relationship like? what type of contributions were made to the relationship. What were the expectations of the child? What was the standard of living of the will maker? What is the standard of living of the child? Was there any gifts made to the child? Was there any gifts made to other people outside of the will?
Prior to the death.
Exactly. And one of the key things is going to be starting to really evaluate the relationship and the cause of the estrangement. And this is some key important things for people to consider, because most people will have, when you've got a dispute, the two people having the dispute, sometimes they agree on the cause of the dispute, often they don't. They often have their own view on how things occurred. You got to remember this. When you're dead, no one is going to be able to say exactly what your side of the story was. So you need to make sure that it's clear from the get-go why you're doing this. Because who's actually going to be giving evidence in the case of a will's variation aspect in this? So say Dad has passed away. Bobby has made a will's variation claim because he was completely cut out of the will. Bobby says...
So he's challenging the will.
Exactly, challenging the will and wants to get the estate redistributed. So say everything's gone to second wife, and Bobby says, I should get half of that. And the court's going to say, okay, Bobby, well, what was your relationship like? And Bobby will say, well, Dad was so mean to me, and that's the reason why he kicked me out. I tried reaching out to Dad, and Dad would always hang up the phone on me. Who's going to be the one giving evidence on that? It's very difficult to consider who would be giving evidence for your side of that story. So it really comes into an importance when you're actually preparing your will and your documents, how to address this. What evidence would be put in front of the court? Just having a simple...
So your will needs to say, I wish it to be known that during the last 10 years of my life, here's what went on. That the person who is preparing the will needs to state in the document what the scenario and the situation was.
Well, we're getting a little ahead of what I was going to give as far as ideas.
We're going to run out of time here.
Okay, so let's jump to that right now then. As far as options then.
Yeah.
Okay, your strongest and best option is always going to be a trust.
Okay.
If you put all your assets in a trust, you know what? There might be certain tax implications depending on your age as far as choices, but that's going to be a lot stronger and it's going to withstand the will's variation claim. If you keep it in your will, you can do a clause in your will addressing it, but you can also do a memorandum to your will. Some people aren't necessarily comfortable about having airing the dirty laundry in the will itself because the will's going to be probated and it's going to go to all of the other beneficiaries.
Right.
So sometimes, depending on the need for privacy, it's possible to do things like a clause in the will that says, I'm going to do a memorandum to my will. And if the time comes, I want my executor to produce this memorandum to explain why I've done this unequal distribution.
Got it.
Because we want to address the moral claim of Bobby and say, you know what? Bobby was beating his mother. That's the reason why Bobby was cut out of the will. I reached out to Bobby. Bobby said he didn't want to have anything to do with me, said I wasn't really his father anymore. I've tried to give Bobby money before, and he refused it. Those are the sorts of things you want to address because it addresses...
Is that integral, that you need to sort of demonstrate what happened in the past? And I just hear this coming from you saying, I tried to give Bobby money, but he refused it, didn't want anything to do with me.
I'm just giving some examples as far as criteria of showing when a moral obligation might be discharged. Now, it's a case-by-case scenario. Not every time is it if you do X, Y, and Z, you're going to discharge the moral obligation because not every relationship is the same. So it's going to be dependent on the relationship for what you're going to want to address in that will's variation question.
Need to take a break. We are in conversation with Colin Flannigan. We're talking about will's variation. We're talking about writing your will. We're talking particularly about children and inheritance, estranged children, and how do you incorporate them into a will, or how are they to be handled within a will? We're going to be back in a moment in conversation. We've got a couple of things that he wants to move forward to, and we'll follow with Colin Flannigan. It's our Tuesday morning law talk, wills, variations, estranged children. If you're dealing with such a scenario, here's your great opportunity for absolutely free to get some additional advice. In studios with us, Colin Flannigan from FH&P. It is our Tuesday morning law talk, a fascinating conversation dealing with wills and variations and the challenge represented or presented by estranged children. in a relationship, however that happened, whether it was divorce, whether it was anger, whether it was interfamily relationships, on and on and on. Sir, over to you.
All right. So right before the break, we started to talk a little bit about options and how to address things.
Yes.
And I don't want to say something isn't the worst thing you could do, but something that I would strongly recommend against is not addressing it when you want to do an unequal distribution. Staying quiet, because not only are we asking the question of who's going to be giving evidence, but certain inferences might be drawn as well, too.
So are you saying that well ahead of your death, as you're the person preparing the will, well ahead of time, you should be discussing your will and why, or should this just arrive once the will is probated?
You should be discussing this at the time of preparing your will.
Okay.
With your drafter, with your lawyer, with your notary. You should be having this in-depth conversation.
But not necessarily those who are receiving the bequeath.
No, not necessarily to the people
that's what
getting
I thought
the gifts.
you meant.
Oh,
is,
yeah, no.
That, discuss this ahead of time with your kids so they fully understand what you're about.
Some families, people do that. Others don't. I would say, personally speaking, I don't know if I would do that.
Right.
But that might be a personal question, whether or not someone wants to have that conversation with their kids as far as expectations. And, that does occur sometimes. Yeah. The way I look at it is this. So when we're talking specifically about saying Bobby is going to be out of the will, or I don't want to give him an equal amount. I might want to just give him $1. I don't usually like those clauses in wills. I do see them now and again.
$1, which is just the ultimate slap across the face.
Well, yeah. Some of the idea on that is to address a legal obligation, but then there's still the moral claim as well, too, in wills variation. So it doesn't really get you there. What we really need to look at is going to say, okay, not explaining why I'm doing this unequal distribution is running a risk, because Bobby can do a wills variation claim. As long as he's going to get notice of my death, when someone applies to probate my will, they have to give him notice. And he's going to have 180 days from the date on which probate's granted to file a wills variation claim. And if we don't address it, it might sort of see, well, why wouldn't I try doing this?
Mm-hmm.
Even though I didn't have a relationship with my dad, I didn't really know him. He probably had lots of money. And
nothing ventured, nothing gained.
Well, I don't want to sound too skeptical, because there is situations where there's good reason for doing wills variation claims, where Dad was in the wrong and Bobby's in the right, and Bobby has been wronged and Bobby should be doing wills variation claims. So I don't want to paint it all with one brush.
Right.
But there's going to be a situation when saying, if it's not addressed, well, why isn't it addressed? And the court might look at this and start saying, okay, what are some of the factors? When did the estrangement occur? How old was Bobby? It seems a little strange that a kid would voluntarily leave home at 15 years of age. Why is that? And certain inferences could be drawn against the will maker. So staying quiet and not addressing Bobby in the will at all is not an advisable course of action.
Okay, so what is the course of action? Let's go there.
Okay, so I already mentioned trust. That's, the strongest situation. The next choice is to properly address it in your will. A well-drafted will, a well-drafted memorandum addressing it. It's no guarantee of success, but at least you're addressing the issue. Bobby might still try to bring his wills variation claim, but the court now has something that can be put into evidence that they can read in and consider and say, you know what, no, this is why the will maker did this. They really did consider their moral obligation towards Bobby. They actually gave it consideration. When they were drafting their will, they'd had this conversation with their lawyer. They went over it, they thought about it, and this is valid reasons why they didn't do it. Or, the other option is this. Spend your money. Mm-hmm. There's a lot of... there is a bit of a culture of inheritance and thinking of entitlement. And you know what? You can't take your money with you.
I've lived a large life. Worked with some pretty intriguing characters. And without being specific, I will say that at one time in my life, I worked for a very successful man who had acquired significant resources and also had 4 children. Mm-hmm. He called 4 children into the boardroom. And he said, kids, I've been watching. And I got to say that you're all sitting around waiting for your share when I kick the bucket. And he would talk that way. Mm-hmm. And he said, I want you to know that I intend to spend every damn cent that I've got. And by the time I kick the bucket, there isn't going to be anything left for you. So you better get out, find yourself jobs, and get to work. Do not be looking at me as the easy ride into the gravy train. Shock the heck out of those children.
And you know what? There's a lot of truth to that, because you can't take your money with you.
Yeah.
You've earned it yourself. Enjoy your life.
Although there is a European expression, and I know European families have a different view of it, where somehow the parents of a European family believe that they are obliged to live a meager and rather plebeian life, close to the bone, because they are sort of called upon to leave an inheritance for the children.
And I do recognize and appreciate that there can be some cultural differences there as well, too. And yes, I do appreciate that and recognize that. On the one hand, that can be a good thing, but on the other hand as well, too, so you're benefiting your children once you die, but on the other hand as well, too, what about their development?
Right.
If someone's always looking forward to receiving this inheritance, the question you just raised in the story you were talking about, get out and get a job. You can't just wait for the gravy train to arrive. For the long-term benefit of your children, if you're teaching them to wait for this reward, are they actually going to learn to...
What are you teaching them?
Are they going to learn to be able to survive on their own?
Yeah.
What happens when they use up that gravy train?
Yeah.
Are they going to be desolate at 60 years old because they never really knew how to fend for themselves? They just relied on inheritance they got at 50 or 40?
Yeah. Back in a moment with Colin Flannigan. We're talking wills, estates, variation, estranged children. We'll be back in the conversation in a moment. Colin Flannigan, FH&P, in our studios. He's a wills and estates a specialist, I guess, for lack of a better word. It's what he wraps his head around on a daily basis, and that's why the conversation that we're having this morning is somewhat vital to me in the sense that, Mr. Flannigan, if you'll permit, there are 3 children in my family. One of them is very much estranged from both my mother and my father. Through a whole variety of circumstances that I won't go into, but certainly, quote-unquote, the black sheep of the family. And so as my mother was preparing her will, anticipating her final demise, it was recommended by her lawyer that while she may want to leave him out of the will in that same way that you were suggesting, I'm going to leave him out of the will, the lawyers had suggested no, that would be a foolish thing to do, that she needed to leave some level of bequeath to him, because otherwise he could challenge the will. But if she made a reasonable bequeath to him, it effectively scotched any attempt that he would have to challenge the will.
Well, let's talk about that one. So first off, I do appreciate your generous statement. Specialist might be a bit of an overstatement for me, though. That's certainly an area I practice in.
Anybody who does what you do specializes in. So,
all right. So I guess one thing we should look at in this is, first of all, changes in the law.
Right.
So the way the courts look at wills variation changes over time as well, too. There was a time when it was if you left something in there, could someone still really challenge it, raise some very serious questions for someone attempting to challenge and vary a will if they receive some level of gift. The courts have moved on a little bit as far as how they evaluate questions, especially dealing with estranged children. Let's really focus on that one. Spouses is a very different category, the way the courts will look at that. Mm-hmm. So I still just want to focus on children today. The courts are going to look at it in the sense they're like, okay, well, if there's some small level of gift, can Bobby still challenge the will? The answer is probably yes. But having left some level of gift in there is still beneficial because it reduces the likelihood of his success. You can show that by giving some level of gift that you turned your attention to it, that you discharged, legal obligations, and you're addressing your moral obligation, and this is what you felt was the extent of it. Then it's going to be on Bobby to show that there was a greater moral obligation to give more than that little bit of a gift. So it's not without a benefit, is what I'm trying to say. Is there's still benefit to doing that? I might suggest, though, that with the way the courts are currently looking at estranged children, we might want to do a little bit more than just give some small level of token gift in there. We're still going to also want to address other considerations the courts are going to look at. because as the courts look at more and more of these situations, they start to weigh different factors, and then the different case laws tell us, okay, well, these are the factors the courts are really going to look at. And, when it comes to dealing with the children, we were already talking a little bit about this, but we're looking at what was the relationship between the will maker and the child. This includes abandonment, neglect, estrangement by one or the other. What's the size of the estate? What contributions were made by the child? Reasonably held expectations of the child, the standard of living of both the will maker and the child, gifts and benefits made by the will maker outside of their will, the testator's reason for disinheriting, the financial need and other personal circumstances, including disability of the child, misconduct or poor character of the child, and competing claims by other beneficiaries. So when we're leaving just some level,
are some of these weighted heavier than others?
It can be depending on...
When I hear you in the second to last statement there, dealing with the character and behavior of the child, that definitely, in our case, came to play.
Well, and a lot of these ones are interrelated, right? So if you look at, we'll use the example of the one we just mentioned, the misconduct or the character of the child.
Yeah.
This often ties directly to the relationship and whether or not there's been abandonment or neglect. So Bobby's been a very bad boy. He's done some terrible things to Dad. He screwed Dad out of, pardon my language, but he, took away Dad's company from him. Mm-hmm. Did a power play in the boardroom, took away Dad's company. These two are related then, because you've got Bobby's character and his behavior related to what caused the breakdown in the relationship. So the court's really going to consider that as what really led to this breakdown in relationship and whether or not Bobby has forfeited his moral claim based on his conduct.
Based on what he's already done to the relationship, done to the fiscal health of the family, so to speak, effectively removed from it significant resources.
Exactly. So these factors are template ones that the court will consider in the different
circumstances. Where are the courts on this? Have you seen enough previous cases, seen enough, decisions made, law handed down that you get some sense of where the courts are going?
I think it's really going to be more so what are the facts of any given case as far as which of these factors the court will put more weight on. Depending on the circumstances of the case itself, you'll see more weight given to certain factors. How the courts generally are looking at will's variation. There was an interesting Court of Appeal decision we were speaking about briefly just off the air now, and that's going to be the Kish and Sobchak estate. It's a 2016 BC Court of Appeal decision, which was it was dealing with a spouse. Well, there was a child involved from a previous relationship as well, too, and everything was left to the child. It was a second marriage.
So the spouse was completely cut out.
The spouse got the house, though, and there was equity in there, and it got assets outside of the estate. And the trial decision in that case varied the will, and, despite both spouses had wanted to leave all of their respective assets to their own children, they didn't want anything to go across to each other and down each other's line of descendants. They wanted to keep it all separate for their own. And they even kept separate bank accounts as well, too. The trial decision felt that based on the need of the spouse, who at this point I believe was facing some capacity issues, felt that the equity in the house wasn't enough and awarded a variation of the estate in $100,000. The Court of Appeal significantly reduced that. The Court of Appeal moved that down to $30,000, and they really went back through a lot of the factors along what were the parties' intentions. And so we don't want to read too much into any one case, but it seems like with this case, there's more consideration being given to the decision-making of the will maker. What was the will maker's intentions? And that's where I think we raise...
Where before that had been set aside or had been reduced, not as much importance had been attached to the thoughts of the original person making the will?
I think that's might be overstating a little bit.
Okay.
I think we're just seeing perhaps, and like I said, we don't want to read too much into any one given case, but we do see perhaps a shift where we are giving a little more...
rebalance?
Rebalance might be a bit stronger, but I think this gives us an opportunity as will makers and will drafters to start saying, okay, if the courts are really going to start considering perhaps more about what the intentions are, let's be extra diligent here. Let's be very clear why we're doing unequal distributions, why we're treating people differently, what are the implications. We know as lawyers what a court's going to look at, so we know what factors to address in those wills variation memorandums.
So if I hear you say anything, and we're just about at the end of our time, but if I hear you say anything, what you're really saying is, as a will is being drafted, as a will is being built, in many cases that document is being built taking into consideration past judgments handed down from the courts.
I think you should be taking that into consideration because you know what a court is going to look at this will and how
they're going to see it
and what factors they're going to consider. So it gives you an opportunity when you're preparing that to address that beforehand.
And then we're presuming success.
Hopefully.
Yeah.
There's never any guarantees, right?
No kidding. Listen, I appreciate your time here, and not that I was trying to get a little free legal advice for my own scenario and situation, but at the time, it seemed that my mother had effectively structured her relationship, with the estranged child, if you will, the way that it needed to be. What I'm hearing you say is that 10 years later, almost 15 now, things have changed.
Well, I'll put it this way. It still makes good sense.
Yeah.
Like from a legal perspective, it still makes good sense. I still understand why leaving some level of bequest can address both the legal and the moral obligations, saying this is the extent of what I feel my moral obligations are.
Mm-hmm.
If there's an opportunity to perhaps do a memorandum to that will and address why you think this small bequest is enough to discharge those moral obligations, what the needs of this estranged child are, might be a good idea to do that as well,
Make sure you get that done.
Extra little bit of protection.
Absolutely. Colin Flannigan can be found at 275 Lawrence Avenue. Those are the offices of FH&P. His direct line, 250 obviously, is 869-6024. But more to the point, the best thing to do is go to the website, FH&P Lawyers, and when you get to the website, there's a drop-down there that basically lists all of the lawyers that are found within the practice and dealing with wills and estates and variations. Absolutely somebody that you should be talking to. Mr. Flannigan, a pleasure to have you in our studios.
Always a pleasure, Phil.
Thank you, sir. We're going to be back in a moment. Got a couple of other quick stories to put the bow on the day to wrap things up. We'll be back in a moment.